board committee back to order. I'm going to summarize where I think we have what we've narrowed down around. It essentially has to do with item 2 and item 4. And whether or not that more is better or less is better for the purposes of complying with what the court has asked us to do. This board is in a challenging situation right now, in the sense that we are trying to meet a timeline so that the ballot language can be prepared to go to voters on time. There is the fine line between making sure that you comply with what the court has asked us to do, while at the same time trying to make sure that if you attempt to summarize it, that you're not leaving anything out that would then not comply with what the court was asking to do. Also in the midst of both sides of the discussion, like different words better than other words in using it to summarize. And so we have at least, I believe, narrowed it down to item 2 and item 4. And I think everybody's had sufficient time to review this. And I want to ask the question of if anyone on the board, is there anything in the, and I recognize that summarizing this language may be more desirable, but is there a belief that what is in 2 and 4 as presented by the staff, Senator Faber explained, that does not meet what the court has asked us to do?
Mr. Secretary.
Yes.
Mr. Secretary, I'm really not sure. I'm not sure I'm qualified to know whether this satisfies what the Supreme Court is asking. I have labored under the belief that we have a higher standard that we can adhere to, which is clarity. I don't think that we have to stick to some minimum standard by the Supreme Court. It's a very serious issue. People have gone out and signed petitions because they want the system to be more responsive to them. And what we're concerned about is in the courts, the majority opinion from the Supreme Court, because of the political makeup, everybody can understand that this would not appear to people as a partisan issue. While they acknowledge that they don't believe that the ballot board intentionally did anything, that they feel that the effect of the previous ballot language was misleading to voters. And what we're struggling with on our side in particular is we don't want to swap misleading for confusing. And what we're concerned is that the technical language that we're using in this version is going to be confusing to a lot of voters. And pursuing summary, and I know this is difficult, and I'm not trying to cast aspersions. This is going to be hard for us to try to work through, Dave. We want to try to summarize this in a way that is as clear as it can possibly be to Ohio voters as to what they're voting on. So I just wanted to add that to the record. That's what we're pursuing. We're very much concerned about clarity. I realize that's maybe a higher standard than what we're asked to do by the Supreme Court, but I think it's a valid.
Senator Faber.
Mr. Secretary, and to the members of the Commission, I certainly agree with Mr. Trayhorn's comments with regard to our goals, and I thought that was our goals before, and it is now. But let's talk specifically what the Supreme Court said in its opinion. It said very clearly that the ballot board can either use the complete text or can use condensed text. However, any condensed text cannot materially omit any substance of the proposal. And with regard to paragraph 2, one of the disputes is that it limited some of the process as to who and how the members were going to be selected. It went on to say the problem was it didn't say anything about who was appointing and how they were going to be appointed, and went on to say that even the other language failed to include that. And so at a minimum, it needed to talk about who would be selecting commission members. And I think to make sure everybody's clear on this, the only way to be clear on this complicated, confusing selection process is to put the exact wording from the constitutional amendment in this section. Let's err on the side of doing the completion side of what the court said we do. Remember, it said we do two things. We can either put the complete language or we can do a summary. But if you do a summary, you have to make sure you don't get it wrong. Well, in this time period, at this crunch, my fear is that if we do a summary, we're going to get it wrong because, frankly, I didn't draft the confusing selection process that's in the constitutional amendment. And it is confusing. I don't know whether we include all of it or part of it, or what parts we include and what parts we don't include that somebody's going to claim as a material omission. And so I guess my answer is to argue that the language that's in the actual constitutional amendment is somehow confusing to the voters is a little axiomatic to say that the people that are proposing apparently a confusing constitutional amendment will therefore make the voters confused. I'm not sure I can get to that logical leap in that order if we include exactly their language. And so I have proposed, if there are other sections that would make it more complete, to help explain that problem, we can go ahead and explain that for paragraph number 2. But I don't know how you can answer the court's confusion in this area by including less. Because at the very time we're going to be trying to pick and choose what we determine as material and what is not material in this area. And the court already argued that our first attempt to summarize it, despite Pfeiffer's concurrent opinion, we thought we had done a nice job trying to summarize it. He didn't like it. So I think the better solution is to include it all. And you are inherently running foul when you try and shorten it with that risk of whether you include all of the material provisions. So if there's something by including this language that you want additionally included, I think that's a wonderful suggestion. Tell us what it is. But other than that, if you want to try and start material edits again, I think you run the risk of violating the court's intention in this area. Mr. Griffin.
Thank you, Mr. Secretary. The Supreme Court did give us instruction on what we should do, and our task is that we're required to properly identify the substance of the proposal to be voted upon. That's on page 10 of the recent opinion. But then they clarify, and they're pretty straightforward in their language. On page 11, they say, first, the voter has the right to know what it is he's being asked to vote upon. So our task is to draft a set of language in which the voter knows the substance of what he's voting on. It should not take 3 years of law school to understand an issue. It should require logic. And the Supreme Court has already written in its back section of paragraph 3 what it believes, in pretty straightforward language, what it believes is going on. And so at an appropriate moment, we intend to propose adopting the Supreme Court's language, which was drafted and approved by 6 justices of the Ohio Supreme Court, which describes their understanding in paragraph 3, page 2, as a replacement for paragraph 2. And when the moment is there, we can have a discussion on that. But I think there is a possibility for neutral ground. You know, we're happy to talk about it and see if there's some way that we can meet in the middle.
Mr. Chair, Secretary, again, I'm not sure that paragraph 3 was intended by the court as a part of an overall fact statement to be the inclusion of the entire process. But again, my question is, the court said you have 2 options. You can either present the language in total, or you can summarize it. And it's when you summarize it that then you start looking at the language. I don't think the court intended, and it certainly didn't say, that it's the ballot board's job to fix the inherently confusing provisions that are in the original constitutional amendment. I think that it's the people who are proposing the constitutional amendment that are responsible for anything that is confusing in their language. And from that perspective, if they're presenting something and proposing something that's confusing and not otherwise using need multiple law degrees ultimately for interpretation. But having said that, I'm still waiting to hear what in the proposed sections are somehow misleading or will defraud or otherwise violate the standards that the court established. And frankly, because we're using the exact language from the constitutional proposed amendment, I'm not sure that you can get there. But having said that, Mr. Secretary, I'm happy to entertain additional discussion.
Thank you. Here's the dilemma we face. The dilemma we face is that we have some pretty clear guidance and I think consensus on 1 and 3 and 5. Where we don't have a consensus is on 2 and 4. And the default position, essentially, at least in the cases 2, is to include the actual language from the amendment itself. And in the case of 4, consensus, but it appears from the discussion that the real hard one here is 2, because I think the concern that we all have in varying degrees is again complying with what the courts ask us to do. And the question is that when you're not precisely sure, when there is a disagreement over it, is to put the actual language itself in there so that you can be assured that everything that the court desires to cover is covered. It may be belt and suspenders, it may be more than is necessary to comply with the court, but it certainly must be adequate to comply with what the court has asked. And if there is a potential for summarizing that in a manner that everyone can agree upon, that would fulfill what the court has asked us to do, then I am willing to entertain that. Although I don't believe that the current, the prospective proposal on the table is as adequate to that task. So, is there a desire to take a few minutes and try to figure this out? Yes, sir. Okay. Then we will stand in recess for a period